In a Wayne County courtroom in Taylor, Michigan, Judge Victoria Shackelford presided over a preliminary examination in the state of Michigan versus Anton Conley. Prosecutor Omar appeared for the people. Defense Attorney Riggins appeared for the defense. Trooper Cody Longuski of the Michigan State Police was the only witness called. A helicopter tracked this car from Detroit all the way to Taylor. The charges were fleeing and eluding under MCL 750. 479A 479A and resisting and obstructing under MCL 750.81d. And behind all of it, quietly attached to the file was something that could double every sentence on the table. Anton Conley did not go quietly the night of his arrest. Trooper Languski made sure of that. Judge Shackelford was the last door this case had to get through. Not everything was going to fit.
Okay, this is 240869, the state of Michigan versus, is it Anton or Antoine?
Anton.
Anton Conley appearances.
And good morning, Your Honor. Omar Shazra on behalf of the people, PA 6332.
And good morning, Your Honor. Good morning to your staff and the services by Ken Riggins, 82125 on behalf of Mr. Anton Conley. Stand with you to my right. Conley, can you state your name correct, please?
Anton Conley.
All right, good morning. Everyone can be seated. It's a time and date set for preliminary exam. Are the people ready to proceed?
Yes, Judge, the people are ready to proceed.
Are there any preliminary matters that need to be addressed?
Yes, Judge, the people are requesting a mutual frustration order of any non-consensual witnesses in this case, Judge. The officer that is going to be the first officer that's going to be called, Judge, is here and present in court. I don't see any other individuals in the gallery other than the defendant's family, Judge.
No, we're ready.
All right, we're
Judge,
ready.
there is also another preliminary matter. Judge, people have put defense counsel on notice that we are going to be adding 2 counts if the proof show, Judge. One is going to be fleeing and eluding forth for P.O. LaForge, and another is resisting and obstructing pertaining to P.O. LaForge as well, Judge. And people are ready to proceed.
Call the first witness, Trooper Cody Longuski, Judge Ken.
Languski.
Longuski.
One more time.
Longuski.
Longuski. Okay, if you can come on up and face me. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, sir, if you can have a seat, Trooper, and if you can start by saying your first and last name and then spelling your first and last name for the court recorder.
Cody Longuski, Cody. Last name is Longuski.
Okay, your witness.
And thank you, Judge. Good morning, sir. Can you please restate your name for the record?
Yes, Cody Longuski.
And how are you currently employed?
I'm a trooper with the Michigan State Police.
Okay, and how long have you been a trooper with the Michigan State Police?
It'll be 7 years tomorrow.
Okay, and are you assigned to any particular unit with that?
Just traffic.
Okay, and were you working in that capacity as a trooper on 5/2/2024?
Yes, sir. Was.
And did your duties take you to the location of Statler Street and Kenyon Street in the city of Taylor, County of Wayne?
Yes, sir.
And were you dispatched to this location at this time, or were you on routine patrol?
I was dispatched.
Okay, and what was the nature of that dispatch?
Our helicopter, Trooper 3, was following a vehicle that had just fled from Detroit police, which brought that car ended up driving all the way down into Taylor.
Okay, and were you in Taylor at the time?
Yes, sir. I was.
Okay, and were you given a description of this vehicle?
Yes, it was a dark in color, black or possibly dark gray Challenger.
Okay, and while patrolling, did you ultimately locate that vehicle?
Yes, sir.
Okay, and what, if anything, did you do?
At that point, he was coming towards me.
Who's he?
Sorry, the Challenger was
Okay.
coming towards me. Where I turned on my lights to effect a traffic stop on him, at which time he fled around my car.
Okay, and you indicated that the vehicle was coming towards you. Were you traveling on the opposite side of the road at that time?
It was a residential. He was coming. Sorry, the car was going west into a curve, and I was going north into the curve as well.
Okay, and so did you have to make a turnaround?
I did, yes.
Okay, and at that point, did you initiate lights and sirens?
I initiated my lights before I made the turnaround.
Okay, and then you turned it on, correct?
Yes, sir.
Okay, and then you followed that car.
The car ended up crashing.
It did what? Crashed where?
It crashed into the secondary trooper that was behind me.
Okay, and so let me just stop you there. Were you able to turn your vehicle around first?
No.
Okay, so it got into the accident prior to?
Yes.
Okay, and when it was coming towards you, could you describe how that vehicle was operating?
At that time, it was driving around the posted speed limit. Once I activated my lights, I could hear the exhaust acceleration, where it accelerated around my car and then onto the wrong side of the road.
Okay, now when you say around your car, did it have to maneuver around your vehicle?
It went around, I don't know if I had to maneuver around. He had a around on his proper side of the road.
Okay, so how close did you get to the vehicle before you initiated lights and sirens?
I was probably, I would say, anywhere from 20 to 30 feet away from the car.
Okay, and you indicated that that vehicle got into a crash, correct?
Yes, sir.
Okay, and were you able to observe that crash?
In my mirror, yes.
Okay, how did it crash?
I saw Trooper LaForge's lights were on. Trooper LaForge went to his proper side of the roadway.
Your Honor, I'm going to object and testify to anything that Trooper Ford did.
Well, he's just talking about he's just talking about his observations. He's not gonna, if he starts talking about what Trooper LaForge actually did or saw, then he's just talking about what he saw.
I saw Trooper LaForge go to his side of the road, and then I saw the vehicle crash into his front passenger side of this vehicle.
Okay, so were you and that Trooper LaForge driving together initially?
We were following each other, yes.
Okay, and were you able to observe Trooper LaForge initiate lights and sirens?
It's just as lights were on, I don't believe the sirens were.
Okay, and then you indicated that there was a crash. Did you turn around to that crash?
Yes.
Okay, what if anything happened when you got there?
After the crash, I observed the Challenger crash onto the front lawn of one of the residents there. And then I observed a black male wearing a white shirt flee from the driver's side of the vehicle.
Okay, and how close were you when you seen that individual?
Might have been 30, 40 feet away.
Okay, and do you see that individual in court today?
Yes, I did.
Can you please state where he's seated in the article of clothing that he's wearing?
Nice, he's sitting next to the defense attorney, he's wearing a green jumpsuit, like a beard.
You're gonna let the record reflect the identification of the defendant in this case?
Record shall so reflect.
Now, as you observed the defendant exit the vehicle, did you pursue him at that point?
Yes, I did.
Okay, and was he responsive to you?
No.
And how so?
So I drove Trooper LaForge running on foot. I stayed in my patrol car with my lights activated. I tried cutting him off in front of him, but he continued to run. I got up. I heard Trooper LaForge giving my verbal commands
Your
to
Honor, I'm
stop.
going to object to him testifying to what Trooper Ford
He's
says.
saying that's what he heard, Judge. It's not hearsay. This is what he heard. It's also an excited utterance.
Well, I mean, it could be maybe an excited utterance, but it's hearsay, whether there's an exception or not. Are you going to tell me are you going to testify as to what you did in response to hearing that?
Yes,
Then it's allowed for that limited purpose.
But Judge, with respect, it could also come in as an excited utterance. This is happening in live
Well,
time.
then you should set up a foundation for an excited utterance.
Okay, and so, Trooper, let me ask you this. Were you guys both pursuing this individual at the same time?
Your
yes.
Honor, again, I object to, he can testify to what he did.
I know, but I mean, if he's trying to lay a factual basis or a foundational basis for an excited utterance, I mean, he's got to ask him some questions to lay that foundation. So I'm allowing it for that purpose only.
Were you running?
Yes, I was.
Did you observe Trooper LaForge running?
Yes.
And at that time, were you given any verbal commands?
I told him to stop or I was going to tase him.
And at that point, were you able to catch up to him?
Yes, I was.
And what, if anything, happened when you caught up to him?
When I caught up to him, I deployed my taser. I only got one probe into his back and then he fell to the ground.
Okay, and what, if anything, did you do at that point?
At that point, he was on his stomach, and then I just observed Trooper LaForge handcuff him without incident.
Your Honor, no further questions for this witness.
Well,
What you just watched is direct examination. The prosecution building its case through its own witness. Here is what matters before the other side speaks. One trooper telling the court what he saw. The problem is the people want more than what he saw. Resisting and obstructing under MCL 750.81d requires proof that lawful commands were given and deliberately ignored. Those commands came from a different officer, an officer who is not in that courtroom today. In law, what one person heard another person say is called hearsay. And hearsay does not walk into evidence without a fight. Defense attorney Riggins just found his opening. Watch how he uses it.
So, you did not see my client commit a traffic infraction in Detroit, right?
That's correct.
You weren't involved in this case in Detroit.
No, sir.
You don't know what happened in Detroit, right?
That's correct.
All you know is that there was a helicopter chopper that was surveilling my client, correct?
Yes.
All right. And that chopper gave a general description of a car, correct?
Yes.
And the best you can say is that when you saw the car my client was in, it matched the description of the car that you were driving, right?
Correct.
This was at nighttime, correct?
Yes.
It was dark, correct?
Yes.
And you were on a public street, correct?
Yes.
You were coming around the corner. You were on Kenyon Street?
Yes.
Okay. And he was coming around the corner. So you were both on Kenyon Street, correct?
Yes.
And you were both driving towards each other, correct?
Yes.
Now, at the time that you were driving towards each other, it was dark, correct?
Correct.
Are there any streetlights on Kenyon Street?
Not that I remember.
Not a well-lit street, correct?
I'm sorry, so
It's not a well-lit street, correct?
I don't believe so.
All right. You driving a traditional trooper car, correct?
Yes.
It's a dark and color car, correct? Do you have the newer headlights where they're flat towards the car? I mean, flat on the hood, or are they the raised ones?
I don't know. I'm not a car guy. Sorry, it's a newer Charger.
That's
all I
fair.
know.
That's fair. So you're in a Charger, correct?
Yes.
My client is in a Challenger, correct?
Yes.
And it's a dark color car, right?
Yes.
And so you turn the corner and you suddenly put on your lights, correct?
Yes.
All right. And did you try to drive into my client's car to stop it?
No.
Okay. You did not turn your car in towards his front wheel to stop him?
No, I didn't.
Okay. And you sure about that?
Yes, sir.
All right. So after that, you say that he drove around you
Yes.
and he ran into your partner, correct?
Yes.
And at that point, he got out the car,
Yes.
all right? And you gave chase,
Yes.
and you immediately jumped out your car. Is that your testimony?
Not immediately, no. I followed in my car for a little bit while Trooper Ford was running.
So what direction was he going in when he got out the car?
So it was on, I believe it was Statler Street. He went south on Statler and then west on Kenyon Street towards Beach Daily.
Okay. And so he was going in the direction that your car was in? Is it
Yes,
what you're saying?
I did turn my car around here.
So by then you had turned your car around?
Yes.
That's what you're saying. And so he got out and he ran.
Yes.
You got out your car and gave chase,
Yes.
and you eventually tased him, correct?
Yes.
Yeah, I have no further question. I have no further question for this witness.
Any redirect,
Nothing further for the people.
and this witness be excused?
Yes.
All right, thank you, Trooper, you're excused.
Thank you, ma'am.
Is there another witness?
No further witnesses for the people.
No further witnesses? Okay, thank you, Trooper.
Thank you.
Yeah, I'd like to play as defense exhibit a Michigan State Trooper helicopter video footage of the chase that night.
Judge, as it pertains to the video, if it's the video of this officer that is present in court's video, yes, correct, the people do stipulate to it, because there's no authentication issues.
What's the video of?
This is the video of the surveillance, helicopter surveillance of my client's car from Detroit to Taylor and the ultimate stop of the car.
And you're not stipulating to the video? Okay, so he's not stipulating the video, how are we gonna get that video admitted?
And the officer's not here for me. Your Honor, then in that case, I'd like to play a portion of the actual stop in Taylor as rebuttal to the officer's testimony.
Okay, so is this squad car or body car? Or body cam?
This is the helicopter footage,
Okay, it's helicopter footage.
and I'm going to use it as rebuttal. The officer said that he did not they did not drive into my client's car, and I have a video that shows otherwise.
Well, where's the squad car video?
I don't know if we have squad car video. I have body cam footage. I have body cam footage of them getting out the car, but that doesn't show the ultimate stop.
What's the people's position on
Judge,
it?
with respect to anything pertaining to the helicopter video, just the people don't stipulate to that. Unless defense counsel can bring in the actual individual that's operating that helicopter for authentication purposes, absolutely, he can play that video.
And
Pertaining to anything with this officer, Judge, yes, he could play his body cam, he's well open to playing his dash cam as well.
And my sole purpose of playing that is for rebuttal. I don't need the officer for rebuttal. Unless he's saying that this video does not show what it actually shows. Yeah, I'm going to throw out the question this time.
Okay.
Judge, the people move for bind over on all counts to reserve argument for we also move for bind over on the 2 additional counts, as stated in the.
And we're going to object to the bind over. I believe the officer testified that he was not aware of anything that happened in Detroit. All he was aware of when he got on Kenyon Street, he was coming around one corner, he saw a car that matched the description of my client's car, he put on the lights and siren, and he turned in it. They were driving towards each other. He didn't show that my client knew that this car was after him. All he showed that here was a car that was coming towards him, and then another car turned towards him. It is a natural reflex to get out the way when someone is driving a car towards you, and that's all that we have here, Your Honor. As far as the additional charges, I don't think we have anything that shows that this officer gave him a command. I think the officer even testified that once he caught up with him, my client was on the ground and was placing him in handcuffs. There's nothing that showed that he resisted anything towards that empty officer. All we have is this officer testifying that he gave a command, and allegedly my client did not comply with that command. So, Your Honor, we object to the bind over. We object specifically to the additional charges, and we object to the police officer cleaning charge.
Judge, with respect to defense counsel's argument, Judge, if this vehicle is being stopped in the first place, it's because this officer, Judge, that testified today was given dispatch that this vehicle specifically was fleeing and there was a helicopter that was following it. Judge, that's the reason for the stop. He also indicated as he made contact with the vehicle and observed that vehicle, he initiated lights, sirens. Yes, he was coming at a direct angle towards him, but he also indicated that the vehicle drove around him and accelerated. How do we know that he accelerated? Because he indicated that he hears the exhaust. Now, Judge, as it pertains to the R&O, this vehicle ultimately crashes into the other trooper's vehicle. And we know this because the officer testifies to making this observation. Not only does he flee from the vehicle, but both officers pursue him, Judge. It takes a taser to ultimately apprehend him, to which point both pursue him and apprehend him and put cuffs on him, Judge. So I think we've met the elements of the crime pertaining to the fleeing on both officers as well as resisting and obstructing, because we know that both officers made those verbal commands and he wasn't compliant with any of those at that time.
You don't have to respond to that.
So, Judge, we believe we met a verdict. We move for bind over.
Okay. All right, look. As to count 1 and count 2, I do believe this is a probable cause standard. It's the lowest possible standard in criminal law other than reasonable suspicion. It's a low standard for probable cause hearing that I'm here to determine today. I have to find that there is some evidence to support these allegations on each and every element of the offense. The officer testified that he had his lights and siren on. He was in a fully marked squad car. I understand that the lighting might not have been that well, but anyone who's lives in this country knows what police lights look like. And the officer testified he heard the vehicle accelerating once he had initiated his lights and siren. He also indicated that after the vehicle was stopped or crashed into the other car, that He identified Mr. Conley as the individual who exited that vehicle. A foot chase pursued, and he gave lawful commands, including the command that he was going to use his taser if Mr. Conley did not stop the vehicle, stop the foot chase. And ultimately, the officer testified that he had to execute that taser to get compliance from Mr. Conley. So given all of that, I do find to a probable cause standard on count 1 and count 2 that the people have met their burden and the defendant will be found over as charged. As to the other officers not necessarily needed for a preliminary exam to get a bind over on those charges, but there has to be evidence that comes in that's admissible, and without a basis or an establishment being set for an excited utterance or some other present sense impression or some other hearsay exception that would allow that statement to come in, and the people did not satisfy that burden with respect to the lawful commands. And given all of that, I mean, it might be fairly obvious that would have occurred, but I'm not here to make determinations on what seems obvious. I'm here to listen to the evidence and make a decision based on that. So there will be no additional counts, but the defendant will be bound over to the Wayne County Circuit Court for all future proceedings. I haven't. Okay, and we have 2 different dates, Mr. Riggins. He is not in custody on
Yes.
our
I was
case.
just discussing that with him. Apparently, he had a probation issue out in Rockwood. That's
20 days.
Okay, so on my case, if he was out on bond, his date would be July 1st, 2024, but he's currently in custody, so the date presumably would be June 10th for the AOI. And I don't know if he intends on getting out. I don't know what the status is of that other case. You know, I'm just giving you 2 dates, sir, so you know you are bound over to the 3rd Circuit Court for future proceedings, and count 1 and count 2 in the criminal complaint. There's also a notice of there's a habitual offender notice on there as well. Yeah, 3rd offense, habitual offender notice, sir, and that could, of course, increase your penalties to twice the maximum sentence of the primary offense of the lesser term. So it's a 5-year felony and a 2-year felony. You're bound over for all future proceedings to the Frank Murphy Hall of Justice, or whatever they're going to call the new building. And that'll be June 10th or July 1st. Your counsel will have to, Mr. Riggins will look into that and make a determination based on your custodial status. Okay? All right, and bond will continue.
Thank you.
Most people believe that if a cop does something wrong, they have the right to push back in the moment. Michigan law does not see it that way. Under MCL 750.81d, resisting and obstructing applies even if the stop itself turns out to be unlawful. You do not get to make that call on the street. That argument belongs in a courtroom, not on the pavement. But here is where the law cuts the other way. The same system that limits what you can do out there also limits what officers can bring in here. Commands given in the field, actions taken by a different officer, none of that walks into evidence automatically. It needs the right witness, the right foundation, the right moment to be raised. Without it, as far as the court is concerned, it does not exist. The law does not only protect the people chasing, it also controls what they are allowed to prove. If there is a case or courtroom moment you want us to cover, drop it in the comments. Subscribe so you do not miss the next.